Welcome back to Courtroom Chronicles, where today's case is about Jennifer Lee Williams, and this one's messy from the very start. The judge openly questions whether Williams is even sober enough to understand what's happening. That's already a red flag in any hearing because appearing under the influence in court can instantly sink your credibility. We're talking about bond violations, missed drug testing, a bench warrant, and now new felony charges stacked on top. From meth possession to resisting an officer, this case has layers of chaos. But here's the twist. Williams doesn't just face her past, she's accused of violating bond while on bond for another drug case. That's what judges call a compounding problem. It's like digging a deeper hole while you're already stuck at the bottom. Stick with me because this judge is about to make a decision that shows exactly how patience runs out when someone plays games with the system.
I'm concerned with Ms. Williams' ability to comprehend what's going on because it appears to me that she is under the influence of some substance based upon her demeanor. All right, our next case is presentation. People of the state of Michigan versus Jennifer Lee Williams. This is case number 25-14094 FH. Appearances from counsel.
Joanne here for the people.
And I'm Jeff Harrison. I'm here on behalf of Ms. Williams. As you may have already noted, she appears electronically from the Webster County Jail.
All right, thank you very much. Ms. Williams, are you able to see and hear the court this morning, ma'am?
Yes, sir.
Thank you. Ms. Williams, we are here today for an arraignment on a bench warrant. This court back on August 1st signed a bench warrant for your arrest. It was based upon an order that you had failed to enroll in drug testing as a term or condition of your probation. I'm sorry, of your bond or your pretrial release. Then additionally, we had a show cause for your failure to enroll in that program, and it looks like you failed to appear on that date, which was August 1st. Now, when someone fails to comply with the court order, it could be treated as a matter of contempt, for which a defendant could be sentenced up to 93 days and or $7,500 in fines and costs. The court recognizes before it, also here in the back, Ms. Alex Matsky from the Western Missaukee Community Correction Program. So, Ms. Williams, we're not going to treat this as an issue of contempt. However, the court chooses to use it as a review of your pretrial release conditions, or in other words, your bond conditions. You have the right to challenge this allegation at a contested hearing and have the prosecutor prove the allegations, which could even be done right now if we so chose. At that, you'd hear some witness testimony. You could cross-examine that witness. You could also present witnesses' evidence or testimony if you chose to do so. And of course, you'll be represented by your defense attorney at that hearing. Again, the court must give you some due process. Now, if you're found to be in violation of your bond conditions, your bond conditions could be modified, continued, or bond could be revoked and you could be remanded into custody. Now that I've told you what the allegations are, what your rights are, and the possible consequences of your choices, I'm going to turn to Mr. Harrison. Mr. Harrison, how does your client wish to respond at this time, sir?
At this point, Your Honor, we would, in light of the fact that she's also set to be arraigned on new charges at 1:30 today, we have no option, frankly, but to do something to contest the bond violation at this juncture as well.
Okay. Well, we have a couple options there. Right now, we're at 9:50 a.m. We could proceed today and take testimony, or
I don't have my file. I didn't know she was going to be arraigned up here today.
Yeah.
I do have the new allegations,
all right.
but I was just brought
I
the
don't think
warrant.
it'll be terribly necessary to resolve this today, Your Honor, unless the court deems it so.
No, it's okay. I don't think the testimony is very complex. It might take all of 30 seconds, but the court will set it for a hearing.
I don't even have the sheet in front of me. I do have the new allegations. I just signed it.
That's okay. So is there another allegation that she test positive?
She had a pipe.
Oh, she had allegedly had a meth pipe. So that will also be dealt with at the hearing. Plus, I'm gonna note that I'm concerned.
Right, okay.
I'm concerned with Ms. Williams' ability to comprehend what's going on, because it appears to me that she is under the influence of some substance based upon her demeanor and presentation today via Zoom.
A similar concern was raised by jail staff this morning, so I feel more comfortable not proceeding today.
All right, thank you very much. Now, I did note that Ms. Williams appeared to make a comment. I did not hear that comment. I'm going to ignore it right now because she has counsel. Her counsel has spoken for her, and we will set it for a hearing. In the meantime, the court is going to deny the defendant bond and remand her into custody until the hearing. Thank you very much. We are adjourned.
Thank you.
I'm sorry, person at the jail, what is your name?
Jennifer,
Williams?
yes.
This is case number 253631FY, the people of the state of Michigan versus Jennifer Lee Williams. We are here for an arraignment. Ms. Williams, did you have the opportunity to meet with somebody from the defender's office today?
Yes, sir.
I have a complaint that alleges that on or about August 8th, 2025, in the city of Cadillac of Wexford County, in count number 1, it is alleged that you did commit the offense of possession of methamphetamine. That is a felony punishable by up to 10 years in prison and or a fine of $15,000. In count number 2, it is alleged that you did commit the offense of police officer assaulting, resisting, or obstructing, in particular, Sergeant Zach Hicks of the Cadillac City Police Department. That is a 2-year felony punishable by up to 2 years in prison and or $2,000, and consecutive sentencing may be imposed if it happened in a place of confinement. In count number 3, it is alleged that you are a disorderly person who is found jostling or roughly crowding people in a public place. That is a misdemeanor punishable by up to 90 days in jail and or a fine of $500. In count number 1 and count number 2, the prosecution has also elected to charge you as a habitual second offender. That means that you have at least one prior felony or attempted felony in your past. That makes the 10-year felony and the 2-year felony punishable by 1.5 times that amount. Do you understand those charges and potential penalties?
Yes.
You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, and historically, I show a jostling in 2019, domestic violence in 20, in 24, larceny less than 200, in 24, an attempted resist and obstruct. There was a 4A case back in 17. In 06, there was an MIP of alcohol, 22, an operating while visibly impaired, and 25, a trespass. It's my understanding that she has a bond violation out of the circuit court for a, I think it was a drug charge and possession of contraband, if I remember correctly. My probable cause affidavit that I read today indicates that she was maybe in absconder status in the circuit court. And I know there was a bond arraignment or bench warrant violation arraignment today in which was set for a contested hearing, if I remember correctly. Probable cause affidavit also indicated that the looks like there was an attempt to apprehend her by the bounty hunters, so to speak, looking for her. Any comment regarding bond defender's office?
I apologize. I wanted to make the court aware that the circuit court, I was informed by Mr. Tubb, the circuit court did not accept any plea from her today because she appeared to be under the influence of something to them. I spoke with her about an hour ago, and that didn't strike me to be the case. So I just wanted to make that statement.
I will state for the record, I did watch her arraignment this morning via the live stream because I was curious what was going to happen. And it did appear that To me, it looked like she may have been nodding off at times, but I'm not sure about that, so I can understand where the court was coming from with that.
I will just say, I would be comfortable with the state of mind that she was in at least an hour ago, and assuming it's remained the same, with proceeding as usual. I would like to say that, the incident, at least where she was picked up here, I don't know, I feel as if mentioning, because I found it sort of uniquely like an awful way to get arrested, was her baby's father more or less tricked her into thinking that she was going to see the child for the first time in 3 years, and then she got arrested. So I thought that kind of sucked. Not that that impacts bond in any way.
Is that from when they were trying to apprehend her for her bond violation?
I believe so.
The bondsmen were trying to apprehend her?
Yes. That being said, she does have a support network that's growing here in the city. She has a partner who she would like to stay with. And then she also has I wouldn't say a job lined up, but work lined up at a house that she can stay in. So that would also take care of housing. She wasn't able to give me the address for that, but it did sound credible to me. So thank you.
I should have also mentioned that the praxis scores her at a risk level 8, which is a high risk. Is there anything about that you wanted to address? I know you already addressed the housing issue and the lead on work.
No, Your Honor.
All right. Ms. Lawrence?
Thank you, Your Honor. I don't think I need to go into too much detail. As the court stated, they read the affidavit on this case. I think it's pretty clear the defendant cannot be successful on bond since she is on bond in circuit court for another possession of meth. And she picked up this new possession of meth while on bond, and also her failure to appear in circuit court as well. Given that, and also the fact that this did happen in a public place, a very busy place at the G&D party store in the parking lot, I do think there are some concerns for public safety in this case. I would ask for random drug testing as well as a $10,000 bond. Thank you.
What was her bond in circuit? Do you remember?
I believe I was told she had a remand.
No, but before she
Oh.
absconded. In my mind, I thought I had changed her previous bond to 25,000. All right, the court finds that Ms. Williams presents as a flight risk in that she was absconding from circuit court bond, and by the praxis, it looks like for over a month, and that she had failed to enroll. I assume that's in testing, at least based on the findings in the probable cause affidavit that I had to review in order to find probable cause for the charges today. It does appear that she was trying to be apprehended by the bondsman's bounty hunters, and it was not going so well for Ms. Williams. So I do find that she is a flight risk. I also find that she's a threat. I am going to order a $50,000 cash or surety bond, since the $25,000 didn't keep her coming back to court or following the bond conditions. Ms. Williams, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also going to order that you not consume any illegal controlled substances, including recreational marijuana, and you'll be subject to random testing. On the situation that you are released from jail, I'm going to order that you be placed on a GPS tether for location purposes only. Ms. Ejomera, anything else?
No, Your Honor.
All right, we are adjourned. Thank you, jail.
Thank you, Your Honor. Have a nice day.
And there it is. The hammer drops. After hearing about Jennifer Williams' history, skipped court dates, failed testing, and even a bounty hunter chase gone wrong, the judge isn't taking chances. He doubles her bond to $50,000 cash or surety, adds GPS monitoring, and flat out calls her a flight risk. This isn't just about punishing her. It's about protecting the public and making sure she actually shows up to face justice. The lesson here? Judges give rope, But if you abuse that trust, the rope gets very short, very fast. So what do you think? Was $50,000 bond fair, or should the judge have gone even higher given her history? Drop your thoughts below. And if you found this case as shocking as we did, make sure to hit that like button, share this video, and subscribe to Courtroom Chronicles for more jaw-dropping courtroom breakdowns.